Good afternoon, and welcome to this opportunity to shape our Risk Outlook 2016. My name is George Hawkins. I'm a Senior Technical Advisor here at the SRA, and I'm joined today by Laura Holloway, an SRA Risk Analyst.
Good afternoon.
Both of us are involved in researching and writing the Risk Outlook, and we really want today to be as interactive as possible, and I hope you enjoy it.
So how it's going to work today is we will do a brief 10-minute presentation to introduce the Risk Outlook and what we want from today, and then it's over to you. We'll pose a series of questions and you can click on the Ask a Question button and then type your views. We'll then read some of them out live. We may use your first name, but we will not use your surname or any information like your place of work. You can also use the Ask a Question button to report if you are having any technical problems with the webinar, such as if you cannot hear us. Below the Ask a Question button, there are two further buttons, Overview and Resources. These enable you to download a PDF version of the presentation. I'll remind you of how to use the web chat once we start the interactive part of the webinar, but for now I'm going to hand back to George, who will talk you through our Risk Outlook.
Some of you may have already seen the Risk Outlook report or our online tool on our website. This is the fourth year we will publish the Risk Outlook, which is our annual summary of the risks that matter to us, including information and how we're managing them. But let's go back a little. Let's talk about the purpose of our regulation. It is to protect the public and to support the operation of the rule of law and the proper administration of justice. And to fit into that, the Risk Outlook summarises the risks that matter to us. For those of you who are new to this, we will give an example of a risk that we currently feel is important. Let's take bogus firms, for example. We know there is a problem with criminals pretending to be solicitors to dupe people or other solicitors into giving away information or money. We collect data and we now have around about 700 reports a year. We also know that there are top tips that firms can employ to help manage the chances of becoming a victim, having their identity stolen, or their client becoming a victim. Now, we use the Risk Outlook to highlight this problem for firms and solicitors and offer solutions to help firms manage the risk, such as agreeing at the outset with clients you will not change your bank details by phone or email, or regularly checking your firm's name online to ensure your ID is not being stolen. The Risk Outlook will also discuss what we're doing to help. For example, we issue scam alerts and keep a register of all firms and solicitors, and we ask people to contact us if they fear a firm or solicitor is not genuine. That's one example of one of the risks. A further risk is cybercrime. We know firms are targets for criminals because of the data and money they hold. Our Risk Outlook sets out what we know about this risk and, again, what you can do to manage it and what we're doing. Now, I won't go through all 8 priority risks from last year's Risk Outlook because we want today to be interactive. We want you to think about risk with fresh eyes and tell us what you think is happening out there as we speak. So these are just 2 examples. Thinking of those examples, in different ways they represent risks to our very purpose of protecting the public and supporting the rule of law and proper administration of justice, and that's why we care about them. If they were not controlled, the market would not be a very safe place to do business and would cause harm to many people. This is why they matter to us. Ensuring we meet our purpose means striking a sometimes difficult balance between, on the one hand, freeing up firms to do business, to grow, to innovate, and on the other hand, maintaining the quality and public protection that is fundamental to the legal sector. Effective identification and management of risk helps us achieve this balance. The Risk Outlook should help you understand why we care about certain risks and help you manage them in your own business. However, there's only so much we can understand from looking at evidence like reports of misconduct, client complaints, firm statistics. We also want to know what's happening in practice on the ground in law firms. Managing risk doesn't need to be expensive, and it can be as much about making the most of opportunities as it is about preventing problems. Essentially, managing risk is good for your business and your clients, as well as your regulator. So we would really appreciate you taking the time today to give us your views and help us understand risk from your perspective. So now over to Laura, who's going to discuss our upcoming updates to the Risk Outlook.
Okay, so we update the Risk Outlook twice a year through our online tool. We also publish papers looking at specific topics in more depth. I'm now going to give you a short overview of our 2016 Risk Outlook Spring Update, which goes live on the SRA website this Monday, the 14th of March. As you can see from the screen, firstly, we've updated our Priority Risks web tool. This web tool allows you to view summary information on each of our priority risks at a glance by clicking on the risk. New content includes updated trend information and new case studies, including some new information on cybercrime. Secondly, we've published a paper on providing services to people who are vulnerable. This paper brings together useful information, resources and case studies about providing services to clients who are vulnerable. However, risk is also about taking opportunities and innovating. So the second paper is all about how IT supports innovation and can help you deliver new services to your clients. So now you know a little bit about what the Risk Outlook is, it's time to give us your views. We're going to move on to the live discussion portion of the webinar. Firstly, I'm going to give you a quick reminder on how to give your views and to ask questions. What we're going to do is pose a series of questions, and then you need to click on the Ask a Question button and type your views. We'll then read some of them out live and have a discussion and find out a little bit more about what your priorities are and why. We may use your first name, but not your surname or place of work or any other details. And just a reminder that you can also use the Ask a Question button to report if you're having any technical problems with the webinar, like if you cannot hear us.
Thank you, Laura. So here's the bit where you come in. We'd really like you to seek out that Ask a Question button and start contacting us shortly. What we want you to do is take a look at this slide. What do you think are the top 3 risks to people who use legal services? So think about your clients, think about the small businesses, think about the people who rely on you to help them when they've got a legal problem, and then think about the risks that are out there in the market. What matters to them? What harms people? What harms the public? And we'd be really interested to know your top 3. Now, the way to do that is to type in the corresponding letter into the Ask a Question box. So, for example, if you think that A, B and C are the most important, you just type in A, B and C and let us know. And if you all do that, we should have a good crowdsourced way of understanding what people think are important. Now, while you're thinking about these, I'm just going to talk you through them very, very quickly without leading you, and then we can hopefully get your views. So as soon as you've decided on your top 3, please do type in the letters into the Ask a Question box, and we'll be able to respond to them as soon as possible. So we'll share these out, Laura. So if I start, so A is about the cost of quality legal services. Is that a risk to the public?
Secondly, we have B, which is the lack of access to redress if something goes wrong, so whether people are able to complain or access compensation.
We have the trustworthiness. We have information and money at risk from cybercrime, the trustworthiness of lawyers.
Falling foul of bogus firms, not enough choice in the market.
Lack of regulation of the market.
Quality of advice.
The profession not reflecting the diversity of their clients.
Dishonest solicitors taking client money.
Not understanding the law and whether something can be done about a problem, so that's the public not having a good understanding of the law.
A choice of different regulatory protections from different types of providers.
Money laundering.
Abuse of the court process.
Poor service, such as delay.
Inability to compare providers.
Lawyers not being independent.
And then as the final one, we've got other, so you can effectively suggest anything that you might be worried about. And Nick, I hope that answered all your question, because Nick got in touch with a helpful question saying you give only your selection of what we might be worried about. But what I want to say is, if there's one or more that you would like to suggest yourself, please do type those in. We just went for a selection that would fit on the slide. So if there are any serious issues that you think we haven't covered, please do type those in.
Yes, to talk about where we drew these issues from, a lot of them are taken from our previous work on previous risk outlooks, and they're taken from our various objectives as a regulator. We've also done a lot of internal workshops where these things have bubbled to the surface. We've been out and spoke to firms at last year's Colton Coffer Compliance Conference. We've also looked at our data and looked at things that seem to be bubbling up and happening out there in the market. So we've really taken a breadth of views into account, but please do use R and tell us which your other ones are, and we'd really appreciate it. So please do all join us and let us know your letters.
Yeah, we've got some coming in already, so thank you to those who are sending them in. We've, I don't know, we're seeing some sort of similar ones and some different.
Yes.
So yeah, please do send in your suggestions, or if you want to send in your own suggestion about some other risks, then please do. We haven't put the risks, the 8 risks that were in last year's risk outlook up on the screen necessarily, but yeah, if there's anything that you want to add in, then please let us know.
We're going to give you another minute or so, please do, don't be shy. Everybody's welcome, and we won't necessarily request that we get into a long discussion backwards and forwards if you don't want to, but what we would like is just for everybody to pick the 3 that they think most matter to people in the market. Whilst we're waiting for a few more responses, Laura, maybe we can pick up on a couple of these, and they've already come in. A couple of people have chosen C, information and money at risk from cybercrime.
Yeah.
We are hearing a lot of this, and we know that it's a real issue for a lot of firms at the moment. Yeah,
it tends to be when we attend conferences, so whether it's our COPPA conference or other events, it is something that practitioners are always wanting to discuss with us. So I'm not particularly surprised that a lot of people have said that they feel that cybercrime is a key issue.
And we'd like to touch on that in a bit more detail later on, but those of you who've come to us so far, we can see that people have chosen cybercrime as a key issue, so we will go on to discuss that. Catherine, thank you for your contribution. I'm really interested in the risk around the amount of choice of different regulatory protections from different types of providers, and whether that's perhaps causing, I don't know whether you think that's perhaps causing confusion for consumers in the market, or they don't particularly know what regulatory protections are associated with which provider. If you'd like to give us some more information on that aspect, please do type it into the Ask a Question button, and we can maybe begin a bit of a dialogue and to understand a bit more why you've chosen that, or indeed anybody of you out there, if you have a view on this. It is risk L, and it's a choice of different regulatory protections from different types of providers. We'd be really interested to know your views on that.
Yeah, thank you, George. And another risk that seems to be quite popular as they're coming in is risk E, falling foul of a bogus firm. So that's certainly something that it does make it into the news. It's something that we release a lot of alerts about on our website. And so I think it's unsurprising again that bogus firms have been a popular choice, and I suppose they do link through to risk C, information and money at risk from cybercrime. So I think it'd be interesting to see if people have chosen those almost as a set together of how bogus firms link through to cybercrime.
Thank you, Laura. Yeah, on bogus firms, it is one of our key risks, as I've discussed earlier on in the webinar. I would direct people towards our last risk outlook, where we had some really useful information on how to control the risk of bogus firms. There's practical steps that you can take, performing regular internet searches using the names of your firm, your partners and staff to check whether anyone is using your details without authorisation, ensuring your details are up to date on the Law Society's Finance Lister webpage, and regularly subscribing and reading our scam alerts and warnings of bogus activity. It really is worth doing that. And of course, when dealing with another firm's solicitors, take steps to verify the identity of that firm. So thank you, Catherine, for getting back to us. You do say that you do wonder whether the general public is aware that anyone can call themselves a lawyer and can be totally unregulated. And that's a really, really interesting point.
Yeah, and that's certainly something that's come up in sort of other solicitors that we've spoke to. So, well, we've done, as I said, discussions with people at conferences, spoken to a few specialist groups, etc. And that's something that's come up there as well. We're not sure whether people aren't aware, whether their clients know that being a solicitor is different from being a lawyer, or whether they're aware that lawyer isn't a protected term in the UK, and whether there's some confusion maybe with America where they call people lawyers and that would generally only refer to somebody that had passed the bar. So yeah, I think it's really interesting. I actually did a focus group with some consumers who are members of small businesses a few months ago, and one thing that came out of that was people who were generally quite savvy about legal services and understood the business world were still a little bit confused about these titles and what meant what. So I think it's certainly interesting that that's come out in this discussion, so that we can incorporate that into the risk outlook. And I suppose that does link to some of the other risks about information. So we have got K, not understanding the law and whether something can be done about a problem. But then I suppose that also links through to L about the choice of different regulatory protections for different types of providers. And I think if there's not that understanding there, it's difficult to make that choice. And so that could therefore also link through to risk F, which is not enough choice in the market. So yes, for me that's particularly interesting. So thank you very much, those of you who've sent your views through already.
Yeah, another one I'd like to pick up on. Nick, thank you for your email and for your message, and I'll paraphrase a little bit. So you talk about our present thinking on regulatory independence, and it appears that we're willing to be active environments which would currently be out of scope. That isn't quite the way I would put it. I would say that what we're looking to do is ensure that the solicitor brand is strong, is protected, and it's a personal brand that follows that solicitor in the work that they do. But also, we are a legal services regulator, and if legal services providers are providing legal services in England and Wales, and I do fit the criterion to come within our regulation, we are willing to regulate those providers in a targeted and proportionate way. We do want to encourage an independent, strong and diverse profession. We are aware that there is strong competition from unregulated providers, and we want solicitors who are perhaps best placed to offer services in the market to be able to work with all kinds of providers and to be able to provide services to all kinds of people. Our thinking is pretty early on this. I'll direct you towards our Looking to the Future paper that was published in November that discusses these kind of issues in a lot more detail, and I'd also point you towards our hopes to consult later on in the spring, perhaps early summer, on some of our initiatives around solicitor flexibility and ensuring that solicitors can truly compete with that market.
Yeah, I think I guess that also links through to Catherine's point about whether people can call themselves a lawyer. And to me, that is interesting because obviously that part is linking it back to the client and saying, well, it's not necessarily about who's providing the service, but it's about the client having enough information to be able to make a decision. And so is there enough choice for clients, or do they find it difficult to discern between these different types of provider? So I think those points kind of complement each other, really.
Yeah. And interestingly, Nick has talked obviously from the supply side on that. So we've talked there about consumers having enough information to choose how they want to purchase legal services. Nick makes a fantastic point, which is, well, as a lawyer, as a qualified solicitor, am I able to choose how I want to be regulated? You obviously have your personal regulation that comes from being a solicitor and being regulated by the SRA and bound by our code of conduct. But yes, you do want to go and work for perhaps a licensed conveyancer. You want to work for an entity that perhaps is regulated by the bar. Perhaps actually you want to go and work for an accountancy firm, for an unregulated firm. As a regulator, we need to face up to these big issues and think, well, how should we regulate Nick in those, in those circumstances? How can that title of solicitor work in the future? What does it mean in the future? So, Nick, I think your question is really valuable. I think it's very much in line with our thinking at the moment, and we are really serious about looking at the solicitor brand, if you like, the solicitor title, and thinking in the future, what will that look like? How will it work? and how can we give solicitors the flexibility to go out and deliver services? Because at the moment there are certain regulatory barriers to being able to go out and deliver services in flexible and innovative ways.
Thank you, George. So thank you very much for those who are sending in their suggestions. And we've had something again from Catherine here around risk E on falling foul of a bogus firm, and that's one that quite a few of you have sent in that is one of your priorities. And she said, I carry out the recommended internet checks weekly, and it's amazing what one can find, including that some of our firm had, without our knowledge, been put onto a dating website. I would recommend all firms carry out these checks. And Catherine, I think that's a really good point, and what we're trying to gather in terms of doing this webinar is from a perspective of a practitioner, what is going to be useful for you for us to put in the Outlook. So if we can put top tips on certain things like falling foul of a bogus firm, then, we want this document to be useful, and we want to be able to put out sort of relatively simple, low-cost instructions like carrying out searches on your own firm that people can apply immediately and don't necessarily involve a lot of amount of money or anything like that. So, I think that's really valid, and we'll certainly consider that in terms of what we put in the document.
Definitely. I think actually the thing that struck me from your answers, and thank you, and keep them coming if there's anyone who's not contributed yet, is that we're seeing a lot of people concerned about cybercrime, about bogus firms, but that third one is perhaps different to what it would have been a year ago, and you do seem very interested in the regulatory landscape, consumers' understanding of the regulatory landscape, and solicitors' understanding of the regulatory landscape. And that's something for us to really take away today. And Jill, thank you for your contact to us. And you've done that as well. You've suggested cybercrime, bogus firms, and people not understanding the law and whether something can be done about a problem. Now, there's been quite a lot of research into this area. And some of the research has shown that when there's a serious issue, when maybe life or liberty is at stake, family issues, people will seek out the expert for the advice. For lots of other issues, people go on a gut instinct, on a kind of risk basis, on whether they want the issue to be dealt with by a professional or whether they will deal with it themselves. Unfortunately, people are still not using professionals. 1 in 10 people with a legal problem use a lawyer. Many people, many small businesses, will look at a legal problem and their first inclination is to do it themselves. And if they can't deal with it themselves, that matter ends there. And I guess what we would like to see with such a burgeoning profession of experts is that legal services are ultimately more accessible to people at a price that people can afford. I noticed nobody thus far has mentioned A, which is about the cost of legal services, and whether that in itself is a risk because legal services are too expensive. I feel like we've kind of flirted around that issue by thinking about, well, if people don't understand they've got a problem, or if people can't compare providers, or if people don't know what regulatory protections apply. But if anybody's got any thoughts on cost, I'd be really interested to know your thoughts. And obviously, we understand that the cost of regulation comes into your bottom line as well. So what we're trying to do as a regulator is trying to address that as well and make our regulation a bit more fit for purpose, a bit leaner, and a bit less burdensome on you, so you can go out and provide those services to people. But I don't know about you, Laura, but the thing that struck me is that we have the traditional risks, the bogus firms and the cybercrime that people have been tackling now for a couple of years, but people do seem really interested in this regulatory landscape that's out there and the idea that consumers need to be able to make good choices. Yeah,
I agree, and I think the risk about risk F, not enough choice in the market, kind of links those two things together. So you've got, are consumers able to choose, for example, a firm that they know has good protections against cybercrime, or would it be impossible for them to tell that? If a firm had been hit 20 times by cyber criminals and lost client money, would a consumer ever be able to find that out? Or is it just a question of they have a chat with them. If they know what questions to ask, they might get a bit of information. And also, how do the good firms discern themselves? So if a firm has had absolutely excellent results from all its cases and offers a really competitive rate compared to the firm down the road, or has different pricing structures you can use, so perhaps you could do a payment plan or fixed fees or by the hour, depending on what you wanted. How do they get that out? How can the consumer compare that with other providers? And that is something that we hear from when we do focus groups, when we speak to consumers. So again, the focus groups that I did with small businesses, one thing that they were really interested in is, well, if I didn't just rely on a recommendation, how could I, find the service that I wanted? How would I find a firm that knew about, for example, could talk to me about the legal aspects of export, etc. So I think that sort of thing is particularly interesting to me. And I don't just think it's about cost. I think it's about, transparency and awareness of consumers, because they also sometimes cost can be about perception. So do solicitors actually cost as much as consumers think they cost? And on costs, we've actually got a message here from Paul, so thank you for that, Paul, who said, the costs of advice are caused by professional indemnity insurance costs and the costs of regulation. And I think that is really interesting, because as George mentioned before, we do need to really think about, well, what is our role as a regulator within this? How does the cost of our regulation impact on the cost of advice? And so a lot of the risk outlook this year, I think, will be about not only us giving you tips on what you can do, but also for each risk talking about what we're trying to do. So it won't just be, if we put cost of quality legal services in there, it wouldn't just be talking about what the issue is. It would also be saying, well, what is the SRA doing to try and manage that from a regulatory side? And Paul, you've also talked about risk H, the quality of advice. So relating the experience that clients come to us to clean up poor advice elsewhere. So I think that really links well through to Catherine's discussion around a choice of different regulatory protections from different types of providers.
Yeah.
So it's interesting to hear that you're seeing that firsthand in terms of, if clients weren't aware of what protection they had or the quality of advice that they're getting, are they then going to another firm to say, well, I was unhappy with the advice that I got?
Nick, just to pick up on your recent email regarding whether we'd be publishing details of firms that have been the target of criminals, we won't be doing that.
Yeah, sorry if I gave that impression. I was just making more of a comment on consumer choice. So yes, we have no plans to publish who's been hit by cybercrime.
No, not at all. No. I guess we're making a wider point about what do consumers need to know about legal services to be able to make informed choices. Mm-hmm. Do they need to know the complaint history of firms? Do firms need to have a kind of regulatory accreditation? At the moment, once you're regulated and authorised by the SRA, well, that's pretty much it. Is it worrying to think about ranking firms? What does that have in terms of the administration of justice and the rule of law? We have a unique sector with a unique set of individuals and businesses, and there will never be a one-size-all-fits approach to regulation of this sector, in my view. The future of regulation doesn't currently appear as one of our risks. You are right, Nick. Thank you for that comment. It does appear as a driver in last year's risk outlook. We know that the role that not only we play as a regulator, but government plays as a legislature, and the regulation that the government has around data protection, around money laundering, and other aspects of running a business, does impact directly on the businesses that are out there providing services, and then further impacts on consumers of those services. We are pretty serious about looking at the cost of regulation. We've taken steps to make it easier for firms to do business. We've slimlined things such as authorisation processes. We've made ourselves easier to deal with, I would hope. Events like today are more common now as well, so you can talk directly to us. What I would also say is, and I'll use the example of the accounts rules, we've taken a lot of firms out of that requirement of providing an accountant's report now. If you have small sums of money passing through your client's accounts, you're not giving conveyancing, you're not doing probate work, but you need a client account perhaps for money on account of costs and small amounts passing through the account. We've also exempted you from that process, which was an expensive process. So I think it's probably worth, for any smaller firms out there with smaller levels of money going through client accounts, to ensure that you keep up to date with the work that we've done on that particular area of our regulation, because we have tried to reduce costs where possible there. But we know there's much more to do. We're serious about reforming our regulatory model, our handbook, making it easier for firms to do business, but also making it easier for solicitors to go out and practice and deliver services. So thank you for your comment, Nick, because I think in this year's Risk Outlook, we will need a really keen eye on this ever-changing landscape and draw together everything that's going on around innovation, competition, consumer choice, and the role the regulator plays in promoting a healthy and diverse legal profession.
Yeah, I agree, and I think when you're saying the future of regulation doesn't appear in your risk register, I do think it's really interesting that you are thinking about how the future of regulation could be a risk to people who use legal services. Because obviously we can talk about what the future might mean for the SRA, what it might mean for solicitors, but we do also need to think about what it might mean for the people who use legal services. So they don't know that there's regulatory reform going on at the moment, or there's discussions about the future of regulation. But we do need to think seriously about, well, if we're proposing regulatory changes, if we're putting things out for consultation, how do we make sure that those who really understand how it impacts people on the ground are responding to those consultations, and how do we ensure that we really understand how changes that are made within firms and within the SRA ultimately go on to impact the people that use legal services or people that want to use them. So I think that's a really important point, and it may have things like the changing regulatory landscape and costs and choice of different regulatory protections may have previously been things that we thought, oh, you know, we'll talk about them a little bit in the Outlook, but they're not front and centre. I think we're realising now that, you know, it is the right time to start talking about, well, how could this actually impact on clients, consumers, people that maybe want to use legal services but can't at the moment, and just bring that all together in something coherent that also gives firms some tips about how they can manage their own risks.
Thank you. Before we move on, because we do have another question, we have covered bits of it, just to address Catherine's point about Risk K. Again, the fact that people don't necessarily understand the law. I've seen a statistic that says that 81% of people are intimidated by the justice system. Yeah, that's quite sad, I think, when we probably have the greatest justice system in the world. So Catherine's suggestion is, I wonder whether the SRA could encourage government to put some basic legal knowledge into the national curriculum as or part of citizenship. I think that's a really innovative and fascinating out-of-the-box idea. I haven't really had full time to reflect on that, but what I would say is that we have supported initiatives such as Legal Choices. I don't know if any of you are aware of that website. You can always open up a quick window and have a quick look at that. The Legal Choices website is really for the consumer who has perhaps never used legal services. They want to know what a solicitor is, what does a solicitor do, what kind of services are offered, what kind of pricing structures exist. There's a great page on for small businesses with a decision tree. So if a small business wants to think about, well, do I need legal services? Who could I use? There's some information there that they can take to a provider and find out from that provider. Also, are you regulated? Who's your regulator? Do you have insurance? What service am I expected? What am I expected to do? What are you expected to do? There's some really interesting content on that Legal Choices website, which is that kind of basic legal knowledge that I think people do need. It's funny because people, when they have a little knowledge, will enforce their rights. We only need to look at people claiming for payment protection insurance, for missold bank accounts. A lot of them are using professional services, i.e. claims management companies, but a lot of people are contacting their banks and making claims themselves, delayed flight compensations another way. I think generally since the advent of the internet age, people are, broadly speaking, more aware of their legal rights, more willing to say no to bad service, are more willing to understand quality. It's just so difficult in legal services because it is so difficult to assess quality of legal services because the information asymmetry normally between solicitor and consumer is a pretty wide gap.
Yeah. No, I agree, George. And obviously we've gone into some of these points in more depth, and that brings us nicely on to the next slide, which is just summarising what we want to know about why you've chosen certain risks as the most important. So we've got some suggestions of what you could go for there. So we've got the impact on clients. We have the impact on the rule of law and the proper administration of justice. We have how likely the risks are to happen, how many people they affect. So we'd really be interested in your thoughts, especially on the more sort of, I guess, traditional risks like cybercrime, bogus firms. You know, how important you perceive they are with regard to how many people they're affecting, how likely are they to happen. Is this something that you're worried about on a daily basis, or is it something you feel that's maybe quite remote, but if it happened, it could be catastrophic?
We've already begun to answer these questions, I think, so just to put it in a framework for you, we said we're going to pick 3 popular suggestions. Why don't we talk cybercrime, bogus firms, and then as suggestion C, we'll have a bit of a mix of those things we were just talking about around consumer access, consumer choice, cost, and the role of the regulated professional in the future of legal services. And Nick, I'm just reading your question through now that you've just asked us about whether we will promote the work of regulated people. This is a really difficult one, I think.
Yeah, it's sort of beyond the scope of this webinar to be answering that. However, we really are interested in questions like this from the profession and engagement like this on the type of proposals that we're putting out with regards to our regulatory reform. What I would suggest is at the end, I'll be going over all the different ways that you can contribute to the way the SRA regulates, so how you can engage with us. And those type of questions are the sort of things that you may want to contact our contact centre or respond to a consultation, and I'll give an overview of those how to respond and how to pose those types of questions at the end of the webinar. So thank you for that. It's really encouraging to see you engaging on our regulatory reform.
Okay, so we've got a few more messages through. Thank you. This has been great to hear from so many of you. I'll just have a look, and Catherine, your note, particularly interesting about risk A, addressing the costs issue. You say for solicitors this is already addressed following the code and the advice of Leo. I think you're right when it comes to being transparent about costs.
Yeah, agreed, yeah.
You know, I think solicitors are much better than that. I've worked at the Legal Ombudsman, I've worked at the Legal Complaints Service, and I've got colleagues who've worked there previously. I think that solicitors have commercial pressures for fixed pricing and fixed costing, but also client pressures in respect of clients want to know they're getting value for money, and that's becoming true both in the corporate purchasing world and the consumer purchasing world. But I think what we're looking at with risk A is actually the level of that cost and whether some services are too expensive for people to be able to access justice. Really challenging issue and difficult issue, but one that I think is intertwined within a lot of what we're talking about around the current regulatory model and the pressures solicitors feel, the costs that they incur in respect of delivering their services.
Yeah, I agree. I think it's particularly interesting talking about the sort of the role of the code and the advice of the Legal Ombudsman in terms of addressing it among regulated individuals, and could the same apply to all providers of legal services? And I think that's really interesting because it's you know, we're looking at things like whether the cost of quality legal services is different from just the cost of legal services. So is quality important? And, you know, what constitutes quality in a service? And I think that particularly with the introduction of things like the Consumer Act that came in 2015, there's a lot more out there in terms of what consumers can expect from any service, regardless of whether it's regulated or not in terms of legal.
I think the thing good point, Laura. I think the thing to remember is that when the current regulatory model was envisaged, statutory protections are fairly weak. If you're using an unregulated provider of legal services now, they also do have an obligation to be clear about cost, a statutory obligation, and they also have an obligation to provide services that are of an acceptable quality. So it's probably worth refreshing knowledge on the Consumer Act when thinking about how the unregulated sector interacts with their consumers. But of course we would always take on board those comments that of course the Consumer Act doesn't have a dedicated regulator looking to enforce it, and it's up to people to enforce their rights under the Consumer Act. So of course there will always be that slight imbalance where people have to enforce their statutory rights against unregulated providers compared to having recourse to legal ombudsman for complaints or to us for matters of possible misconduct.
I think there's also a really interesting point there that's come in about whether if all providers of legal services are subject to the same requirements, so whether that was regulatory or having to report to the legal ombudsman, etc., would that help with risk P, the inability to compare providers? So do consumers find it difficult to compare to providers because they're all regulated in different ways, and if they were all regulated the same, would that help people compare? And it'll be really interesting when we speak to consumers at our events to say, well, is that why you find it difficult to choose a provider? Is it because you feel that you don't know what the difference is between a solicitor and a lawyer and a licensed conveyancer, or is it something more fundamental like it's difficult to compare quotes, or you don't know how much experience they have in your type of work? And I think, honestly, at the moment, we don't necessarily know what the answer is. We've done various focus groups where consumers have said, I just always go on personal recommendation because I don't know how to compare people elsewhere. We've got, some people might say, I wish there was like a compare the market but for solicitors, whereas others are like, well, that would be far too complicated. You can't compare solicitors in the same way that you can compare mobile phone insurance, which I think is also a valid point. So I think it will just be about us continuing to engage with consumers and saying, well, what does make it difficult for you to compare providers, and then try and think about, as a regulator, what we can do to respond to that.
Thank you, Laura, and thank you for everyone for your interactions. We're going to move on now, but yeah, special thank you to all of those who encouraged our discussion, and we hope we've given you some answers. And thank you, and we will ensure that we have full transcripts of everything that you've said that we can properly digest and reflect a little later on today, and your comments will feed into this year's thinking on the risk outlook and what should be in the risk outlook. So it really is vital that we have these kind of discussions, and we thank you all. So moving on, we've listened to you regarding what you feel should be in this year's risk outlook. Let's have a look at what was in last year's. So we had the poor standard of service to vulnerable consumers, misuse of money and assets. Interesting, we didn't have that discussion today.
No, we didn't. We didn't have. No one mentioned the dishonest solicitors taking client money.
No.
So, obviously, the reason behind that may be, just in reference to the previous slide, be because it is a very small proportion of solicitors that misuse client money. So perhaps it is just that, yes, it's a big risk, but it's quite rare. And so these things like cybercrime, bogus firms, and the regulatory landscape sort of
more common concern.
Yeah, and they apply. They could potentially apply at every firm rather than misuse of money and assets. It's quite rare, so perhaps that's why it didn't come up. I'd be interested to hear your views if that is correct or not.
Yeah. A lack of a diverse and representative profession. Nobody online at the moment felt that was a risk that was in the top three to people. So should solicitors reflect the diversity of the consumers? That's a really interesting issue.
Yeah.
We've got lack of independence, improper or abusive litigation. I take these two together normally, very interesting cases. We did some research on independence in the city, and we can see that pendulum swinging towards clients who now demand so much more of their solicitors that solicitors really need to keep a tight hold of that moral and ethical compass. Improper or abusive litigation, we issued a paper called Walking the Line, Balancing Duties in Litigation, which touched on some of the pitfalls that solicitors can fall into when litigating, when they feel that they're perhaps the hired gun for their client and not thinking about the duties they owe to the court and other third parties. So please check that out. Information security and cybercrime and bogus firms, the next two. So these are the two that many people this morning still felt were critical, and we'll take that thinking forward into this year's Risk Outlook, I think.
Yeah, definitely.
And finally, money laundering. Again, not mentioned in today's discussion is that perhaps because it's a little bit like misuse of money and assets. Huge impact when it happens, criminal acts, but rare for people actually out in the profession doing a good job like our good people today online.
I think also it's interesting because we did actually specify for you to think about the top 3 risks to people who use legal services. And money laundering and misuse of money and assets, one of the things that we hear increasingly from practitioners is there's a big impact there in terms of the reputation of the profession. So, you know, is it about that it's about that impact on the misuse of money and assets and money laundering on the the reputation of the profession and that one consumer, or do we look at things like bogus firms that could potentially affect thousands of people? And I think it is right to think about that type of thing. And just a little bit before we go, I'd like to tell you a little bit about what the future holds for the Risk Outlook work. And we have our spring update out on Monday. We have our Risk Outlook 16-17, which we're consulting about today, to come out in the summer. We have our ongoing programme of regulatory reform. So there's consultations that have been on our website, and if you go through the About Us section, there's lots of information about that. And then a little bit about, in response to some of the questions that we've had today that are more about our reform programme, you can contribute to the conversation on those through consultations. So we always put out formal consultations on changes that we want to make. Events. So, if you want to attend one of our conferences, like our COPPA conference, or we've got an upcoming innovation conference. And then also through other webinars. So there was, for example, another interactive webinar a bit like this a few days ago, which covered some of the education proposals that we're thinking about. So that's really important. And, it's really encouraging to see how many people have got involved today and have signed up for this webinar and have been giving their views, and it really will contribute towards our Risk Outlook. Just to finish by saying, we haven't had time to respond to any of the particular points you've raised, and obviously we have had limited time, so we haven't been able to get to everyone, but don't worry, all your views will be saved on our system and will feed into evidence for the Risk Outlook.
Yeah.
So if you just wanted to know a little bit more about the other evidence that we collect, obviously we look at, we do quite a lot of data analysis. So we look at data analysis about, frequency of reports about different risks coming in. We look at information about cases that are going to the tribunal, things like that. We look at data from the legal ombudsman, for example, and so that's sort of the data that we use. But we also speak to others. So as well as you guys, we're speaking to people at the forthcoming innovation conference. I've spoken to a number of different specialist groups. So I had a really good conversation a couple of weeks ago with the Mental Health Lawyers Association, which was really helpful, and just trying to get different perspectives on what risks we should be including. We also talk to our own frontline staff, so we're aware that we do a lot of research and analysis, but we're not working directly on the front line when reports come in or speaking to sort of clients. And so it's really important that we get their views in as well. So we just want to get as broad a range of evidence as possible, and we felt that it was really important to, get the views of members of the profession like yourselves. So that kind of concludes today's webinar. We've finished about 10 minutes early, but all is left to say is thank you very much for your participation, and please do get in touch with the SRA, whether that's via the contact centre or through consultations, if you would like to further contribute to the regulatory change that we're thinking about. Thank you very much.
Thank you, Laura, and thank you everybody for joining us today.